Privity of contract determines who can enforce a contract. In general terms, only one who is a party to a contract, the one who has provided consideration, can enforce it. In many instances, though, privity of contract can defeat the intentions of the parties to a contract and can lead to substantial injustices. For this, many methods have been devised at common law to provide third parties to a contract with a means of circumventing a strict application of the doctrine of privity. The Contracts Rights of Third Parties Act of 1999 provides parties to a contract with a statutory method of circumventing the doctrine of privity of contract to provide third parties to the contract with the right to enforce contractual terms. The doctrine of privity of contract is primarily concerned with the question of who can enforce a contract. There are two aspects to the doctrine of privity of contract. The first is that only parties to a contract are bound by it. The second is that only the parties to a contract can derive rights and benefits from their contract. At common law, the parties to a contract cannot impose a burden on a third party, nor can they confer a benefit on a third party. See, for example, Tweedle v. Atkinson from 1861. The first aspect of privity, that the parties cannot by their contract impose liabilities or burdens upon the third party, is unobjectionable. The circumstances in which justice calls for such a result are very limited. The second aspect, that the parties cannot benefit a third party to a contract, is however objectionable. There are many situations in which the parties to a contract clearly intend to confer an enforceable benefit upon a third party. The denial of the benefit to the third party defeated the intention of the contracting parties and often produced manifest injustice and commercial inconvenience. The Contracts Rights of Third Parties Act of 1999 implements the recommendations of the Law Commission. Note that it reforms the doctrine of privity, it does not abolish it. The common law devices which circumvented the effects of privity are therefore still effective. Under the Act, a third party to a contract can enforce a term of the contract in his own right in two circumstances. First, where the contract expressly provides that he may. Second, where the terms of the contract purport to confer a benefit upon him and nothing else in the contract denies the purported benefit. The right of a third party to enforce a term of the contract is subject to the terms of the contract. This means that the parties to the contract can impose conditions upon the third party's ability to exercise his rights under the contract. The application of Section 1.3 of the Act was considered in the case of Avramidis v. Colwell in 2006. The Court of Appeal held that Section 1.3 required the contract to expressly identify the third party by name or class. The right of the third party is additional to any right that the promisee might have to enforce a contract. Generally, the parties to a contract cannot rescind the contract or vary it in such a way so as to either first deny the right of the third party or second, alter the entitlement of the third party once the third party has acquired the right to enforce the term of the contract. The third party receives protection from such later changes to the contract in two instances. The first is where the third party has communicated his assent of the term to the promissor. The second is where the promissor is either aware that the third party has relied upon the term, or the promissor can reasonably be expected to have foreseen that the third party would rely upon the term, and the third party has relied upon the term. The Act provides that the contracting parties can provide otherwise in their contract. They can contract to allow a rescission or variation of the contract without the third party's consent, or they can obtain the consent in a different manner than that set out in the Act. The common law allowed claimants to bypass privity through various mechanisms, including the following. Enforcement by the promisee. This is an obvious proposition, and it is essentially what occurred in the case of Beswick v. Beswick. The estate of the promisee was able to enforce the promise. Two difficulties can arise when the enforcement is to be made by the promisee. First, the promisee may be unwilling or unable to enforce the contract. Secondly, it might be difficult to find an appropriate remedy for the third-party beneficiary. The courts have dealt with cases involving third-party rights in the following types of situation: multiple bookings, as in Jackson v. Horizon Holidays in 1975, seller contracts with carriers to take buyers' goods for delivery, such as in the Albarezo from 1977, contracts where the subject matter will be acquired by a third party, as in Linton Gardens Trust versus Lenesta Sludge from 1993, and an order for the promisor to perform, as in Beswick versus Beswick. Agency. Agency is not so much an exception to privity as a general commercial necessity. Shanklin Peer versus Dettel Products Limited from 1951 is a case at hand. Occasionally, legislation uses agency to avoid the difficulties caused by privity. Exemptions and limitations of liability. Courts have stretched the agency concept in one particular situation to provide the third party with the benefit of the exclusion clause in a contract. This was established in the case of the Everymedon, New Zealand Shipping versus Satterwhite from 1975. Collateral contracts. Occasionally, a third party may be made liable on the basis that he has made some promise in consideration of the promisee's entry into the main contract. See Andrews versus Hopkinson from 1957. Trusts. It as owner of the promise to constitute a trust of the promise. See Lloyds versus Harper from 1880. Legislation. A statute may overcome the problems that would otherwise be posed by privity.
We can see a contemporary application of Section 13 of the Act in Chadley versus Clydesdale Bank from 2019. Section 1.3 provides on the rights of third parties to enforce contractual terms. It says the third party must be expressly identified in the contract by name as a member of the class or as answering a particular description, but need not be in existence when the contract is entered into. Chadley involved a situation where a contract between a bank and an investment company specified how investors' funds were to be held. In these circumstances, the Court of Appeal held that the investors were entitled to sue the bank for breach of contract in their own right under the 99 Act. The purpose of the contract was to protect investors who, although not expressly named, were sufficiently identified as a member of a class. In contrast, in Bates versus the Post Office from 2019, assistants working in post offices were not able to bring an action in their own right under the Act. It could not be said that contracts to which sub-postmasters and the post office were parties were entered into for the purpose of training assistants. It seems that the training of assistants was an incidental effect of the contractual performance of the sub-postmasters. One specific area of contemporary significance in relation to third-party rights is data protection. After instruments such as the EU General Data Protection Regulation, known as GDPR, and the California Consumer Privacy Act in the USA, the legal environment governing data has changed significantly, and this affects the rights of third parties under contracts relating to the collection and use of data. As per the GDPR Article 4, a data controller is the entity, person, organization, etc. that determines the why and the how for processing personal data. A data processor, on the other hand, is the entity that actually performs the data processing on the controller's behalf. In this context, third party means a natural or legal person, public authority, agency, or body other than the data subject, controller, processor, and persons who, under the direct authority of the controller or processor, are authorized to process personal data. Other important points include that the third party would be considered the recipient once personal data is disclosed to it, and legitimate interests of third parties can also be used as a legal basis and to justify processing of personal data by the controller where relevant. The consequence of these definitions is that third parties may have responsibilities for the use of data and find themselves subject to liability in ways that transcend our contract law-grounded definitions of rights and liabilities arising from consensual agreements. Anyone working in a field involving data will need to inform themselves of these new frameworks to ensure compliance with a complex set of rules. And in case you were wondering, the relevance of the EU's GDPR transcends any domestic legal frameworks instituted post-Brexit in the UK.